Welcome to Burned and Betrayed, Stories of Trust Broken and Lessons Learned. She walked into that courtroom on a Tuesday morning in October carrying a banker's box, a 3-ring binder held together with 2 rubber bands, and 18 months of her life compressed into paper. Her name was Renata Solis. She was 43 years old. She had no law degree, no paralegal certification, no legal assistant experience of any kind. What she had was a 9th grade education, a library card that had been swiped so many times the magnetic strip had worn smooth, and a wrong that had been done to her so severe, so calculated, so coldly executed by people who believed she would never fight back, that something inside her had stopped being afraid and started being dangerous. The courtroom was not large. Civil Division, Room 7, a mid-sized county courthouse in the kind of town where everybody eventually knows everybody, especially the lawyers. The opposing counsel that morning was a man named Gerald Pratt. He had been practicing civil litigation for 22 years. He wore a suit that cost more than Renata's monthly rent. He had won cases that had made the regional legal papers. He had a framed photo on his office wall of himself shaking hands with a state senator. He was the kind of man who had learned, somewhere along the way, that confidence delivered early could break an opponent before the game even began. He looked at Renata when she walked in. He looked at her banker's box, her rubber-banded binder, her clearance rack blazer. And he smiled the particular smile of a man who believes he already knows how the day ends. What Gerald Pratt did not know, what he could not have known, because he had not taken her seriously enough to find out, was what those 18 months had actually looked like. Let's go back, because the story doesn't start in that courtroom. It starts in a rental property on the east side of town, in a 2-bedroom unit that Renata had lived in for 6 years without a single missed payment. She had raised her daughter there. She had nursed her mother through the final months of a long illness there. That apartment was not glamorous. It was not large, but it was hers in the way that only a place you've poured your ordinary life into can be yours. She knew every creak in the floorboards, every trick the radiator played in February. She had painted the kitchen herself, a pale yellow that caught the morning light just right. Then the building was sold. The new ownership group, a property management LLC registered in a state 3,000 miles away, sent a notice 60 days later. They were renovating. Renata needed to vacate. When she pointed out that her lease had 14 months remaining, she was told, with bureaucratic smoothness, that her lease had been reviewed and that certain provisions allowed for early termination under the circumstances of a capital improvement project. When she asked for specifics, the letters stopped coming. When she showed up at the property management office, she was told the regional manager was unavailable. When she called, she was put on hold until she hung up. When she hired a tenant advocate, a volunteer from a local nonprofit, that advocate sent 2 letters that were never answered. And then one morning Renata came home from her overnight shift at the distribution warehouse where she worked to find a notice on her door. 3 days. She had 3 days to vacate or face formal eviction proceedings. She did not have money for a lawyer. The legal aid office told her their civil housing docket was backed up 8 months. The tenant advocate had exhausted their capacity. The small claims limit in her state wouldn't cover what she was owed. And so here was where the story could have ended, the way these stories so often end, with a person who has every right in the world and no resources to enforce it, slowly absorbing the blow and moving on because moving on is the only direction available. But Renata Solis did not move on. What she did instead, on the morning after she received that 3-day notice, still in her warehouse uniform, still smelling of the overnight shift, was sit down at the kitchen table with a yellow legal pad and write at the top of the page, in capital letters, "What do I actually know?" Underneath it, she began to list everything. The lease, the date it was signed, the terms, the date the building sold, the date the notice arrived, the gap between those last 2 dates. She wrote it all down. She didn't know if any of it mattered. She just knew that if she was going to fight, she needed to understand what she was fighting with. The public library became her second home. Not the internet, not primarily. The library, with its actual legal reference section, its bound volumes of state landlord-tenant statutes, It's access to a legal database that a librarian named Phil quietly showed her how to use, even though technically it was reserved for attorneys. Phil never asked her why she needed it. He just showed her. She would later say, in the years after all of this was over, that Phil the librarian was the first person who treated her like she was capable of figuring something out. She never forgot it. She started with the basics. Landlord-tenant law in her state. What a lease was, what it meant, what a landlord could and could not do with one. She read slowly, carefully, taking notes in her yellow legal pad with the focused deliberateness of someone who knows they cannot afford to misunderstand. She looked up every term she didn't recognize. She read case summaries. She read statutes. She read the annotations beneath the statutes that explained how courts had interpreted them. It was slow. It was exhausting. She was doing this while working overnight shifts, while raising a teenager, while managing the low-grade panic of someone who doesn't know where she'll be living in 90 days. But she kept going. Every night she could steal. She went back to the library or back to her kitchen table and she kept going. And that's when she found it. Buried in the state's landlord-tenant code, in a subsection that dealt specifically with building sales and tenant lease obligations, was a clause that the new ownership group had apparently never read carefully enough, or had read and hoped she hadn't. Under that statute, when a residential building was sold, existing leases did not automatically transfer with any modified terms. The original lease terms held. Capital improvement provisions that allowed early termination existed, but they required specific language to be present in the original lease itself, language that had to have been agreed to by the tenant at signing. Renata pulled out her lease. She read it 3 times. Then she read it again. The language wasn't there. Not even close. Whatever provision the ownership group claimed allowed them to terminate her lease early, it did not exist in the document that bore her signature. They had made it up, or more precisely, they had hoped she'd never check. That was month 3. By month 6, Renata had read enough case law to understand what kind of civil action she could potentially bring, in what court, under what theory. She had documented every piece of communication she had received or attempted to initiate, the letters, the ignored calls, the visit to the property management office, the dates and times of everything. She had gotten a copy of the building's sale record from the county recorder's office, which was public information, something she hadn't known before. She had cross-referenced the dates of the sale, the new ownership registration, and the notice she received against the statutory timeline requirements, and found a second violation. The notice itself had not been delivered within the window required by law after a change in ownership. 2 violations. 2 concrete, documentable violations of state law. She filed pro se. That means she filed for herself, as her own attorney, which is a right any citizen has and which most lawyers will tell you is almost always a terrible idea. Gerald Pratt, when he received the filing and saw that it came from an unrepresented plaintiff, probably allowed himself a moment of quiet satisfaction. Pro se litigants are frequently disorganized. They misfile documents. They miss deadlines. They don't understand procedure. They make arguments that sound emotionally compelling but have no legal foundation. They are, in the candid assessment of most experienced litigators, easy. He filed a motion to dismiss within 2 weeks. Renata spent 4 days in the library responding to that motion. She cited case law. She cited statute. She laid out her procedural timeline with the kind of precision that comes not from legal training, but from someone who has read the same rules so many times they have become instinct. The judge denied the motion to dismiss. It was the first time the system acknowledged that she might have something worth hearing. By month 12, she had taken 2 depositions, both of property management employees she had subpoenaed, which she had figured out how to do from a procedural guide she found in the legal reference section. The depositions were uncomfortable for everyone. The employees had not been prepared for someone who had done her homework. She had the lease. She had the sale records. She had the statutory language. She asked quiet, specific, undeflectable questions. She did not perform anger. She did not editorialize. She just asked, and waited, and noted the answers in her yellow legal pad. One of those employees said something in deposition that he probably didn't realize was significant. Renata wrote it down, circled it, and spent the next 3 evenings finding the case law that made it devastating. Gerald Pratt had been retained at month 10 when the ownership group realized this was not going away. By then, the case had more structure than he had expected. He reviewed the filings, acknowledged internally that she had not made the procedural errors he'd anticipated, and began preparing a defense that centered on challenging her damages calculation and arguing that even if there had been a technical violation, the harm was not quantifiable in the way she claimed. It was a reasonable defense. It might have worked against an opponent who wasn't prepared. She was prepared. The morning of trial, she arrived early. She set up her side of the plaintiff's table with the quiet efficiency of someone who has rehearsed this in her mind several hundred times. She had a copy of every exhibit. She had a trial brief she had written herself, 61 pages, organized by issue, with legal citations embedded in the text. She had a printed list of every witness, every exhibit, every argument in the order she intended to present it. She had a notebook for notes she would take during testimony. She had 2 pens. Gerald Pratt arrived with a junior associate, a rolling cart of files, and the unhurried ease of a man on familiar ground. He glanced at her setup. He said nothing. But there it was, that smile, the one that said he knew how the day ended. His junior associate didn't even look at her. The judge entered. The room settled. And then the judge did something that Gerald Pratt had not anticipated. He looked at the briefing, looked at the plaintiff's table, and said, for the record, that he wanted to note that the plaintiff's pretrial submissions had been, and he used this word precisely, thorough. Gerald Pratt's expression did not change, but his associate looked up from his notes for just a moment. Renata gave her opening statement standing up without notes. She had memorized it, not because she was trying to impress anyone, but because she had lived inside this case for a year and a half, and she knew it the way you know the layout of your own home in the dark. She spoke clearly. She did not use legal jargon she didn't understand. She did not perform confidence she didn't feel. What she did was tell the truth, in order, with evidence attached to every claim. She explained what the law said. She explained what the ownership group had done. She explained, specifically, how those 2 things did not match. She spoke for 14 minutes. When she sat down, the courtroom was quiet in the way courtrooms get when something unexpected has happened. Gerald Pratt's opening statement was polished and professional. He challenged her damages methodology. He argued that any violations were technical rather than substantive. He was good at this. He had done it many times. But somewhere in the back third of his opening, he made a choice that would cost him. He looked at the jury. This was a bench trial. No jury, just the judge, which Renata had specifically requested because she believed the law was on her side and she trusted the law more than she trusted the variable of 12 strangers. He looked toward the gallery, really, and he made a small gesture toward the plaintiff's table, a subtle but unmistakable physical editorial, the kind that says, "This is what we're dealing with." He didn't say anything improper. He didn't have to. The gesture was enough. The judge saw it. Renata's case unfolded over the course of the morning with a methodical precision that drew, from the court reporter and the gallery observers, the particular quality of attention that is really just the human response to watching someone do something well. She entered her exhibits in order. She examined her witnesses with questions that were short, clear, and targeted. She did not over-examine. She did not grandstand. When she got to the deposition testimony of the property management employee who had said the things she'd circled and spent 3 evenings researching, she played the relevant section of the recorded deposition, paused it at exactly the right moment, and asked the judge to note for the record how that testimony aligned with the statutory provision. She then read aloud. The judge noted it. Gerald Pratt's cross-examinations were competent. He found some edges. He raised some genuine ambiguities. He was not as far behind as the morning was beginning to feel. But then came the question of damages. Renata had not asked for a number pulled from emotion. She had documented everything. The cost of emergency relocation when she had been constructively forced to leave. The cost differential between her previous rent and the market rate she had been forced to pay elsewhere. The loss of a deposit she never recovered. The statutory penalty for the lease violations, which under state law was calculated at a specific multiplier she had found, verified, and cited in 3 separate places in her trial brief. Her total figure was specific. It was supported. It was, on the law as written, correct. Gerald Pratt challenged the multiplier. He argued the statute she cited applied in a narrower set of circumstances than she claimed. It was his strongest moment of the trial. Renata waited until he had finished. Then she opened her binder to a tab she had labeled, in her careful handwriting, Damages, Statute, Case Authority. She asked the court's permission to address the opposing argument. The judge said yes. She cited 3 cases by name, gave their reporters, and explained in 2 paragraphs exactly why the multiplier applied under the specific facts of her situation. 2 of those cases had been decided in the same circuit. One was only 4 years old. Gerald Pratt did not have a response to the 4-year-old case. He had not found it. He should have. It was precisely on point. There was a recess at midday. Gerald Pratt and his associate stepped into the hallway. Whatever was said between them in that hallway was private. What was visible to the bailiff and to the court reporter who stepped out for coffee and happened to pass them was that Gerald Pratt was no longer moving with the unhurried ease of a man who knows how the day ends. The judge rendered his decision that afternoon. He did not reserve judgment or schedule a written opinion at a future date. He ruled from the bench, which judges do when the case is clear enough that deliberation is not required. He found for the plaintiff on both violations. He accepted her damages calculation in full. He applied the statutory multiplier. He noted, in his verbal ruling, that the plaintiff's legal work had been, and again he chose his words with visible care, impressive in its organization and accuracy. He said this while looking at Gerald Pratt. The total judgment was just over $90,000. Renata Solis sat very still for a moment when the number was read into the record. She had done the math. She knew what the number should be. She had calculated it dozens of times at her kitchen table in the middle of the night. But knowing something and hearing it spoken aloud in a courtroom, official and irreversible and real, are 2 very different experiences. The woman sitting next to her, her daughter, who had taken the day off school, reached over and took her hand. Gerald Pratt gathered his files without speaking. His associate gathered the rolling cart. They did not linger. In the months that followed, people would ask Renata what she would say to other people who found themselves in situations like hers, outgunned, underfunded, dismissed before they even opened their mouths. She thought about this for a while before she answered, because she was not someone who gave quick answers to serious questions. What she said was this. She said that the most dangerous thing they did to her was assume she wouldn't understand. Because the moment she decided she was going to try to understand, the whole thing changed. She wasn't smarter than Gerald Pratt, she said. She wasn't faster, or more experienced, or better connected. What she was more motivated. And motivation, when it is the specific and focused kind that comes from being genuinely wronged and refusing to accept it, has a way of compressing time. Of turning 18 months of library tables and yellow legal pads into 61 pages of trial brief. Of turning a 3-day eviction notice into a $90,000 judgment. She also said something else, something quieter. She said that she thought a lot, during those 18 months, about all the people who never got to that library. About the people who received the same kind of notice, the same kind of bureaucratic runaround, the same calculated bet that they wouldn't fight back, and who simply, for reasons of exhaustion or fear or the honest crush of too many other problems, didn't. She thought about them, and she didn't feel superior to them. She felt the weight of the system that counted on them not fighting. She felt how that system had calculated the odds and decided it was safe to wrong her. The fact that the calculation turned out to be wrong was not, she said, only a victory. It was also an indictment. The ownership group paid the judgment within 30 days of the ruling. They did not appeal. Their attorney, in a subsequent case involving a different tenant in the same building, a case that Renata had nothing to do with, but that she followed when she heard about it, settled early and on terms substantially more favorable to the tenant than any previous settlement from that company. Renata allowed herself to wonder whether the 2 things were related. She still lives in the same county. She has used a portion of the judgment to stabilize her finances, in a way that had never been possible before. She still has the yellow legal pad. The first one, the one she started the morning after the 3-day notice, the one that began with, "What do I actually know?" She keeps it in a drawer. She doesn't look at it often, but she knows it's there. There is something that happens inside a person when they discover, usually at great cost and against considerable resistance, that they are more capable than they were told. It is not quite pride. It is something older and more structural than pride. It is the experience of having tested the boundary of what you were supposed to be able to do, and found that the boundary was a lie. Renata Solis walked into room 7 of a civil division with a banker's box and a rubber-banded binder and 18 months of her own unlikely education. She walked out with something that no court ruling can actually grant you, but that a court ruling can sometimes confirm. The knowledge that you were right, that you were capable, that you did not need permission to fight, and that the people who smiled because they thought they already knew how the day would end were, in the end, wrong about all of it. The lawyer smirked at her opening statement. By noon, he had stopped smirking. By afternoon, he was packing up a rolling cart and walking down a courthouse hallway with nothing left to say. And Renata Solis, warehouse worker, tenant, mother, self-taught litigant, and the most dangerous kind of person there is, which is someone who has been underestimated, sat at the plaintiff's table and felt the quiet, unspectacular, absolute satisfaction of a woman who did the work.